Our Ohio Farmland leasing update. It's a special edition of our Farm Office Live, and we're sure happy to have you with us. On behalf of my colleagues that are joining me today and will be presenting and also helping behind the scenes, we're sure glad that you could join us. We're looking forward to this one. It's a topic that can be filled with a lot of concern, and a lot of folks are always wrestling with what those lease rates should be and how do we set up our leases. Also, looking at the ways that we might be able to better codify our leases. Hopefully, you're looking at written leases. And we're going to go through a number of these issues today as we address these many things. You can see the topics that we have laid out. Going to talk about cash rent outlook and some of the various fundamentals that are going to impact rents in the near term and longer term as well. Looking at negotiating capital improvements on leased farmland. And the one thing that typically comes up is how we manage installing field tile in farmland and how that relationship and how the lease looks in a situation where we are installing some of these capital improvements, dealing with conservation practices in a farmland lease, executing and recording farm leases, very important, and then farmland leasing resources. So that is going to be the topic list for today's webinar. Here's our group today, our team. I'm going to be speaking later. We're going to have Robert Moore, Peggy Hall, and Jeff is also with us today and going to be helping. I think he's dropped in the chat feature the link to where you can access the slides that we'll be covering and using today. This is going to be recorded, so you can access this at a later date as well if you want to review and go back and look at some of the issues that we're covering today. And as far as communications during our webinar today, if you have questions, if you have content questions, we would like it if you would put those in the Q&A feature. Now, you have two different ways to interact with us. The Q&A feature and also the chat feature. In the chat feature, we're going to be dropping in different things relating to the webinar. As I mentioned already, we've got the link where you can access the slides for today. It also allows you to just make comments to us, the instructors, and to the whole webinar room if you so choose. Not where we would like to see the questions per se. We'd like those again in the question and answer feature. Okay, with that, I'm going to stop my sharing and I'm going to turn it over to Robert, and he's going to take over and discuss issues relating to capital improvements in a leasing arrangement. So I'm going to stop and turn it over to Robert.
And Barry, before Robert starts, I think you had the wrong slide up there to begin with. I'm sorry, I didn't catch that, but our legal topics are slightly different than what the slide indicated. So Robert's covering drainage improvements, and then we'll be talking about terminating farm leases and pore space leases. So just wanted to correct that before we get going.
Sorry,
I didn't catch that earlier.
We caught some earlier titles. Sorry about that.
Okay. And is my slide up just to make sure my sharing's working okay?
You're all set.
So the first slide here, I'm not Bruce Clevenger, perhaps as much as I may want to be. But the reason I have his slide up is Bruce has developed a nice spreadsheet that calculates the payback period for installing drainage tile. And Bruce had another commitment today, so he couldn't join us. But I wanted to at least give you a preview of it. And you can contact Bruce if you'd like your own copy. And his email is on this slide. It is primarily why I have it up. So I'll give you, show you the spreadsheet here. Okay, so what this spreadsheet does is it allows you to input tile information, such as what's the lateral spacing going to be, and then all of the different costs and then you put in your crop prices, put in your current yields, input your expected increased yields due to the addition of drainage tile. And then most importantly, it gives you back the payback period. So in this case, the payback period is 7 years for corn and 15 or 7.4 years and then 15 for the price increase. So anyway, this just gets you a number of the payback period. Now, why is that payback period important for leasing? That's what we're going to talk about next, because somewhere around 50%, 40 to 50% of the farmland in Ohio is leased. And we often hear tenants and landlords discuss, well, yeah, the farm needs new tile, but who should pay for it? The person that owns the land or the person that will more directly benefit from the yield increase, which is the tenant? And there's basically three different three different ways we can approach this. And I'm going to go over the three different methods and some of the things, some of the issues you may want to address in a lease, depending on which option you go with. So when we talk about who should pay for the drainage tile in leased land, perhaps the easiest option is for the landowner just to pay it, because the landowner owns the land. Should the landowner just pay for the land improvement, the tile? And it probably is the easiest. The issue I see a lot is landlords may not want to pay $1,000 an acre for tile because it takes a while for them to recapture it. Maybe they simply don't have the resources to pay $1,000, $1,200 an acre for tile. But those landlords that do have the resources, they can simply install the tile. And then there should be a provision in the lease that says, if I put drainage tile in and we presume that that drainage tile increases yields, then I want the rent to reflect that. So we'll put some kind of provision in that says, once I put in the tile, it's installed, then the following crop year, we're going to increase the rate by X amount. Now, what should that amount be? Well, that's where you can use Bruce's spreadsheet to at least in part come up with an answer for that. So another option, and this is an option that maybe landlords and tenants may not always think about, but that is the tenant pays all the cost of installing the drainage tile. Again, the tenant may have more resources, more cash flow to be able to pay for the tile, and the tenant, because they're farming, it's an active operation, they may be able to expense that tile rather than depreciate it over the life of the tile. So they may be able to capture those costs and help with their cash flow and income tax management. So it can often be advantageous for the tenant to pay for the tile. But then we get into the obvious issue of, well, what if I pay $1,200 an acre to put tile in and then the lease gets terminated? Well, what we need to do in the lease itself is write in a provision similar to the one that's on the screen that says, okay, tenant, you can put the tile in, you pay the full price, but, and the first thing is the length, the term of the lease should be long enough so that the tenant can recapture their expense, their investment. That's where Bruce's spreadsheet can be very handy. But what happens if the landlord does terminate it early? If it gets sold, something like that? The lease can say, if the landlord terminates the lease early before the tenant recoups their investment, then the landlord owes the tenant a proportionate share of the cost. So if we got a 10-year lease and landlord terminates the lease in year 5, then the landlord would owe the tenant half the cost of the tile. So what this does is it gives the tenant some assurance that if they make this large investment in land they don't own, that they will either recoup their investment through a long-term lease and that additional yield revenue, or they will get reimbursed for a proportionate share if they don't, if the lease were to be terminated. Another option is we share the cost. And that's okay, no problems with that. But some things to look out for. And first thing is, should you agree on the contractor? And, maybe the landowner may want to have a say in the contractor, even if the tenant is paying for it. But we want the contractor to be mutually agreed upon, probably want both parties to have some say on the design. Where's the main going? How wide are the laterals, things like that. When is the drainage going to be installed on? And then perhaps most importantly, or at least an issue you may not think about, and that is who gets to expense or depreciate the tile. Because we don't want landlord and tenant to share in the cost, but the tenant thinks that they get to depreciate or expense the entire amount. So typically it would say whatever share you pay for, that's the share you get to depreciate or expense. So it's just important upfront to know who's paying for what and who gets the benefit of those expenses. So again, I just wanted to make some really brief comments on this. This is a project that we just started working on, and we're going to have more information in the future as Bruce develops his spreadsheet and his data more. Our thought is we're going to put all this information in one combined publication where you can go and review how to calculate your payback period, and then how to incorporate that payback period and other issues with putting drainage tile in leased land. How do you incorporate that into a lease to make sure both the landlord and the tenant are protected? Again, if you want that spreadsheet, it is available now. You just have to email Bruce. He will email the spreadsheet and you can begin using it now. But again, just wanted to introduce the concept in our Farm Office Live webinars we'll be doing starting in September. You'll be hearing more about this project as we develop it, and we'll continue to address it. Any questions? Check out, see anything in chat. So, all right, with that, Peggy, am I turning it over to you?
Yes. I see that something popped up in Q&A, but I haven't seen it yet. Is that a
Okay.
question
Okay.
for
If tenant
you?
pays the tile and expenses, does the landlord incur any tax consequences? For example, rental income inputted for each year tenant gets a credit for paying. Barry, I may want your help on this. If the tenant pays tile and expenses, does landlord incurred? I don't think the landlord would have any tax consequences.
No.
I mean, the landlord's always going to pay income tax on the rental income, probably not self-employment tax.
No, that investment, I agree with you, Robert, that investment into the rented land does not mean that the landlord has to recognize any gain. So yeah, I agree with you. No.
No rent. I'm sorry, I'm not following. No rent.
I think they're following. Is it a follow-up question? So no rent is paid. They're only compensating the landlord with peeled tile installation.
Oh, okay. So you're not paying rent, you're just putting the tile in, and that is the rent.
I think that's the point that they're making. And
I gotta know, Barry, what do you think? I assume their landlord would have to show some kind of income from that.
I don't think so.
No? Okay.
I don't. I've not
Hmm.
seen it quite. I haven't
How,
seen an example quite like that.
how about this? How about we address this in a future Farm Office Live instead of us guessing? It's a great question. So we will put this on our list to address in the future, but thank you for the question. I think somebody asked about Bruce's email. I will put that in the chat as well. Okay, anything else?
I think you got it
Okay,
all, Robert. Thank
okay.
you. All right, and I've asked Robert too to chime in on the topics I'm going to cover. I'll be talking about lease termination and some of the legal issues that arise with termination. And then also following that, I'll talk a bit about pore space leasing, which we're starting to see in Ohio. So let's start with this issue of lease termination, because we have seen problems over the years with what we call wrongful termination or improper termination, or even um, confusion and a breach of contract because of a lack of clarity on termination provisions or the parties using a verbal lease. So termination does differ, of course, if you're under a verbal lease. And that is now dictated by our new state law in Ohio that addresses statutory termination of crop leases. But a written lease would not be subject to that new law if that lease does address termination. And a well-written farm lease, we would expect to address how and when the lease terminates. So termination differs depending on the type of lease that we're dealing with. And we still think there are a good number of verbal leasing arrangements floating around out there. Somewhere around 40 to 50%, unfortunately, could be operating under a verbal lease, and that causes a lot of consternation when it comes to termination. But I also want to make the point that sometimes termination and renewal are just two different sides of the same coin, and we sometimes bundle those provisions together. And and that will answer the question, is the lease terminating or is it renewing? There are different approaches to that. Many leases are written to have an automatic termination at the end of a period, or alternatively, many leases are written to have an automatic renewal unless either party terminates. So very different approaches that you can take that need to be negotiated between the parties on how you want this to function, this type of arrangement. Do you want to visit every year and renegotiate, or do you want to just automatically renew? Or are you really willing only to go for a certain period and just end the lease without even discussing the possibility of renewal? Very different approaches that can be taken. So here are some examples of language that you might use in a leasing situation. The first one shows you an automatic termination at the end of a specified period, and pretty clear, lease shall end at the end of the year, or the lease period will be from here to here. And there is nothing about either renewal or any notice of termination that's required. It's a very simple, straightforward, automatic termination. Another option would be to have an automatic renewal with the notice of termination that would be required. That's the second example. The lease shall renew for another period unless either party delivers a written notice of termination to the other party by a certain date. And I'm just using simple dates here but those dates clearly would be something that you'd want to agree upon for your arrangement. The third shows you an automatic termination with the renewal option. So that's kind of flipping it around the other way, and says if the parties do not agree to renew the lease prior to a certain date, then the lease shall terminate on a later date. So this one uses September 1st. If we don't negotiate and agree to renew, then we're going to end at the end of the year. So very different approaches that can be taken. And I think I worry sometimes that maybe, you use a lease, you sign the lease, and maybe the parties haven't given careful attention to which of these approaches have we utilized, and what do I need to do, and make sure I know what those dates are and what my options are. Robert, anything you want to add to that? When you were in private practice, did you prefer a particular approach, or did you find that your clients preferred a particular approach to this?
I would say most commonly it's probably the second, where it just automatically renews unless terminated. And more often than not, both parties are happy with the lease and we just, let it continue. So I've seen all of them. All of them will work just fine, but probably that second one is most common that I see.
It's really important to know if you have that second one, you need to know and understand what your options are for when you need to deliver that notice of termination, or else you are just going to flip right over into another lease period. And typically we're seeing those lease periods extend. Robert, I know you've talked about that used to be way back when I started, we just saw these year-to-year leases, but now we're seeing slightly longer terms. So this could be that, at the end of your 3 or 5 year term, I think those are becoming more common. Then we're going to flip over for another term. Is that how you would write that? Or would you say,
I would actually write it that after the term, it renews on a year-to-year
just
basis.
year to year, then we're
Yeah.
going to go year to year. So that's yet
Yeah.
another variation that we could see.
Yeah, I probably would not have it renew for another 5 or 10 year period. Just kind of convert over to a year-to-year.
Good, good. So many options there, and important, of course, for the parties to talk to one another and make sure you clearly understand which of those options you're entering into when it comes to renewing and terminating the lease. When we get into a verbal lease, it becomes much more complicated and risky. Of course, we would all say, we attorneys like to say, put your lease in writing, put your lease in writing. And our reasons for that are to reduce that risk of operating under a verbal lease. And I would say one of the biggest risks is this termination risk. So without those clear provisions, you don't quite know for certain what's the beginning and end of your lease period. And I've seen court cases where they've just argued over that. When did the lease actually start, and when did it end? And even if we're looking at our past practices, when did that happen? You need to know that so that well, have you terminated before the lease ended, or is it too late? So a lot of issues when we have a verbal lease where you don't even have that clarity on the end of the lease period. And if your mode of practice was this kind of automatic renewal, which, as Robert said, is typically what we have seen in Ohio, it just automatically renews unless somebody stops it. Is that, at what point then do we decide you're not going to automatically renew? Another problem with a verbal lease. And so very risky. How do you protect your investments if you don't know, especially if you're the tenant operator who's at risk of that lease being terminated without sufficient notice to you before you've made investments in, and assuming you'll have that land for another lease period. Those kinds of issues led to the statutory termination law that we do now have in Ohio for verbal farm leases. And I guess, Robert, I should make a point that I'd said they're disfavored by Ohio law. They truly are. The statute of fraud says we shouldn't even recognize a lease if it's not in writing, but it happens. Yes, it happens a lot. Anything you want to add to that on the working with a verbal farm lease?
Well, they're still very common. And most of the time they work out just fine. But when they don't work out, it's a real problem. And it can cost the tenant a lot of money, or we end up in litigation over it. So uh,
Right.
just even a pretty basic, simple written lease is much, much better than a verbal lease.
And I think part of the hurdle of a verbal lease is if you do end up in court and litigation about it, your first hurdle is you have to prove to the court why they should enforce a lease that should have been in writing.
Mhm.
And that burden is on whoever's trying to enforce it. And so yeah, can be costly, can be risky. So that's why we have this new, relatively new, it's been in place a couple years now, the statutory termination law. And you'll find it in the Ohio Revised Code. I've given you the section there where you will find the law. And what it says, and note, it only applies to crop leases, not to grazing leases, only farm crop leases. And it says if that leasing arrangement doesn't establish a date or a method for terminating the lease, then a landlord who wants to terminate that lease must do so in writing by September 1st. So a couple of points to note there. It could apply to a written lease. It's not just for verbal leases because it doesn't use the word verbal leases. It just says a lease that doesn't address termination. So if you have, and we've seen some very, very brief one-page leases that don't address whether that lease is renewing or terminating or how, this law would step in. And it clearly steps in a verbal farm lease situation. So if that's the case, then this law kicks in, and note that it applies only to landlords. It doesn't say anything about if a tenant wants to terminate the lease. It says the landlord who wants to terminate the lease must do so in writing by September 1st. What isn't addressed in this law is, okay, so if you don't, then what? Or if you terminate on September 2nd or 30th, or then what? That's not written into the law, but the assumption is that if termination isn't made by September 1st, then the lease kicks over for another period, as those parties have been functioning. So it would just go on for another period. But please recall, it does not say that in the law. And it also doesn't address under what terms. So if the landlord didn't terminate, and it continues on, can the landlord still, after September 1st, change some terms, such as increasing the rent? It doesn't address that situation. But again, the assumption is that we would just continue for another period in the way that the parties have been operating in the past. And if you look at a lot of our case law on farm leases, what has been important in those older cases is we're just going to go with what's the customary practice between these parties. And so we'd have to look at how you have been functioning under your verbal leasing situation.
Yeah,
Okay.
before we came on, I thought you made a really good point of what if the custom is every year, two, three, they bump the rent up. What exactly is the custom there? So uh, it can still be challenging.
It can, and this law doesn't address that. It just says if you don't terminate by September 1st, you can't terminate properly, but it doesn't say you can't revise some of the terms after September 1st. So we do have some clarity with this law that I think does help us with a lot of the situations that we've seen in the past, but still a few things are gray when we're dealing with verbal leases, which is an excellent reason, yet another excellent reason to put that lease in writing and avoid all this. You don't want to have to rely on the statutory termination law. Okay, so what happens if termination isn't proper? Well, we call that wrongful termination, or alternatively, a breach of contract. And so if one of the parties doesn't terminate according to those procedures that are laid out either in the lease or in the statute, and then tries to terminate with that kind of faulty termination, then there could be a legal claim that the other party would have for wrongful termination. So if one party gives notice after that termination deadline, or if the notice wasn't given in writing as required, for example, by the statutory termination law, and that would usually be in a written lease as well. Or if they didn't deliver the notice properly, a lot of times we'll have a provision in the lease that says notice must be delivered here to this address in this way. So if they didn't follow those procedures, there could be defective notice of termination, wrongful termination, a breach of contract type claim that could arise from that. And that non-terminating party could make a claim and seek to either continue the lease despite that wrongful termination, or seek damages if that party insists on acting out the termination that was wrongful. So now we could be in, again, kind of a conflict situation, and we have expenses, money, risk that we have to deal with because of that wrongful termination.
And we often think about wrongful termination as far as usually it's the landlord terminating and the tenant, is out. But I know we've talked about this before. What if it's June 1st and it's been super wet and we just have a verbal lease and the tenant says, you know what? I'm not going to lease this farm this year. So it can go both ways. Usually it's more detrimental to the tenant, but landlords need to protect themselves as well.
Yeah, so we would think about, okay, what is the harm caused? And in Robert's example, there clearly the landlord could be at risk for lost rents. And often we write into a lease that at the end of the period you're to return that lease to the baseline. So whether you need to apply some fertilizer, some nutrients, do some tillage, whatever that baseline is, the landowner could be out for that as well if that didn't occur because of this wrongful termination by the tenant. But most often, as Robert said, we see wrongful termination being the landowner who has tried to terminate a lease too late. And so the claims that we often see by tenants in those situations are for those lost profits that the tenant operator would have had if allowed to continue to lease the land. And many times we see that inputs have already been purchased or some even applied. And so we have the loss of those inputs and services that the tenant may have already incurred before that termination was given. So certainly some problematic situations and some numbers that we have to put on to these types of harms and damages. Here's an example from a real case, and this was prior to our statutory termination law, and yet another example of why we needed that law to try to bring a little bit more clarity to these verbal leasing situations. But in this one, the landowner tried to terminate the lease on April 8th. Which is almost as late as you were saying, Robert, with June, but April 8th, that's a very, very late termination. I would never write a lease with an April 8th termination allowance in it. But in that case, and this was a verbal farm lease, in that case, the tenant successfully sued that landowner and also brought in the other tenant operator that the landowner was trying to lease the land to. So the landowner is, as we say in our family, was trying to change horses in the middle of the stream and move over to a different tenant who was offering a higher rent. And so the tenant operator sued both that landowner and that tenant operator who tried to come in and take over that land, sued on tortious interference. against that tenant operator and won on all claims. And not only received the lost profits, and I've given you the numbers there. I think this was about 120 acres of land, and this has been probably about 8 or so years ago. So base the numbers on that, but you can see the lost profits that the tenant operator received, tortious interference against that other operator, and punitive damages against that other operator, because the first tenant was able to show that the second tenant knew that the first tenant had that land under a verbal contract, had already done some improvements, was preparing for the next crop year. And in this situation too, because of those kind of wrongful claims, the tenant also received attorney fees. So quite a significant award there, all under a verbal lease that kind of went awry.
Peggy, would you agree? When I saw this case, these damages, I don't think they're a bit on the, what's the right word? I don't want to say excessive, but
Yeah,
normally you don't see punitive damages. Normally you pay your own attorney fees. So I think
yeah.
this might be a little bit on the extreme side, but look at those attorney fees, over $50,000 just to litigate this lease issue.
Yeah, I agree. I think if we took that other tenant out of the picture, it would have been a different award. But I do think, this was a jury award, so I do think that first tenant was
Mhm.
able to kind of capitalize on, this isn't right. You just can't come in here and do this. I think that's the tone I got from that case. So you're right. This hopefully would not be common, where it would be this late, and it would be because, and I should clarify, this was an elderly landowner who I think may have been somewhat persuaded by that new tenant to rent for a much higher amount. So, and if you look at the case, that second tenant even admitted, I wanted to get my foot in the door in this county. So that was all going on too. So yeah, a little bit unusual, but a good illustration of why let's just not even mess with these verbal situations, and let's put it in writing. Another issue, and Robert, I think you had to deal with this before too, and we just talked about a case recently that just was at, I think last month, came out, where we had the death of a party. So what happens when that party made the agreement, the lease, and then dies? Well, typically in a well-written lease, we would address that. And we would see, you can see there a provision from a sample lease that we have on Ag Lease 101, where it says this agreement, this lease shall be binding upon the heirs, executors, administrators, and successors of both parties, unless, we agree otherwise. So to reduce risk, that kind of provision would say, if we're in the middle of a period and one of us dies, we're going to make this lease binding until the end of that period on those successors. But if you don't have that clarity, which you wouldn't in a verbal lease situation, again, you're opening up the opportunity for litigation. And that happened in another lease situation, another case, a different case than the last one I was talking about, where the jury found in favor of the tenant, who actually did have a written lease, but there was vagueness as to whether that was binding on the successors. And so the landowner died, and one of the landowner's children wanted to try to terminate the lease that on the land that she inherited. And in that case, they said, no, you can't do that. It is binding upon the successors to that party. And there was even an issue there about with an LLC, but still the tenant operator won that case. So another one to be aware of. Robert, and did you have any issues with that you want to share?
Uh, I did one time. There was a lease that did not have a provision about binding on heirs.
And it was
And
challenged
yeah,
somehow.
yeah. So just that simple little term you have highlighted in there. fixes the whole problem. Just make sure that's in your lease.
And typically, that would be binding for the remainder of that lease term.
That's right.
And then we'd have to bring those new parties together to negotiate a new lease. So it's only for the remainder of that term.
And Peggy, I don't know, maybe you'll address this later, but having that provision recorded as well.
Actually, no, I didn't, but thank you for noting that, because I have some thoughts here on avoiding termination issues. The first one is use a written lease, but that should say and record the memorandum of lease to make that public record. So thanks for pointing that out, Robert. So that's the first thing, is just using written leases. And, I think sometimes there's hesitancy to do that. I know when I presented someone with a written lease on my land, the response was, "What? Don't you trust me?" I mean, I think that still happens.
Yeah.
But I think you just got to deal with that and do it, because the risk is too high when you're in a verbal leasing situation. So use a written lease. And make sure you do clarify and understand those renewal and termination terms. And remember, sometimes they go hand in hand, and you need to understand how those two terms function together. Are we renewing? Are we terminating? What are the dates? What are the deadlines? If you are operating on a verbal lease and you're a landowner, then you need to meet that September 1st written notice of termination requirement that's now written into Ohio law. And I would recommend putting reminders on your calendars of your deadlines. Make sure you know what those periods are. In fact, I just read this morning, I don't know if you saw this, Robert, did you see the Speedway case that the Supreme Court of Ohio just decided? Now, it's not a farm lease situation, but it is a lease renewal situation. And the one party didn't send a notice of renewal in time. It was past the deadline, and there was a lot of risk there. They stood to lose everything they had invested in the property if they didn't give the timely renewal notice. And this happened a couple of times where they didn't do it, and yet the other party kept going along. Well, finally, they tried to renew too late after the deadline, and the other party said, "No, we're not renewing. You just lost everything you've invested in the property. It's now ours." That's what the lease says. And the Supreme Court upheld that. And the argument there was it wasn't some kind of mistake or technicality. It was negligence on the part of that party that they kept forgetting to renew in time. So making sure you know those deadlines and you meet those deadlines is really important. So put it on your calendars, put it on your phones, wherever you need to put it, have several different reminders and follow those procedures. A lease should outline, here's how you give notice of renewal or notice of termination. Here's where you send it. Here's how you send it. Is a text message enough to terminate a lease? Well, a well-written lease probably would not say, here's how you do it. We're going to just text me and let me know. It would be a little more formal, easier to document, easier to verify, certain that the party received it. So follow those provisions for how and where. And then maintain any documentation of what you do, especially if you're under a verbal lease, which again, we disfavor, but if you do send a text or send a letter, or make sure you have copies, have a conversation, and can document what happened. And then remember, this is something that we sometimes see where there are some side agreements between the parties. Even if they're working with a written lease, they'll say, "Oh, well, don't worry about what the lease says. Here's what we're going to do." Those side agreements are not enforceable unless they're put in writing and made a part of that lease as an amendment. So don't rely on those side agreements, verbal agreements that aren't documented and put in writing. Robert, anything else you'd like to add to that?
Nope.
Okay, whoops, sorry, just went the wrong way. All right, are there any questions I can answer? I don't have the Q&A box open.
There are questions. How about I read
Okay.
them to you? Does this become a bigger problem with landlord or farmer succession planning?
Succession planning. Hmm.
I think we kind of address this in that make sure you have a lease with a provision that is binding on heirs and successor
Mm-hmm.
owners. That would be how I would answer that. If we don't have that provision, it can be an issue for succession planning because when the landowner dies, it may be a bit of a free for all of do we have a
Yeah.
lease or not? So just
Yeah. And there was a case where the son of the deceased tried to take over, and the landowner said, no, I don't have to lease it to you. So yeah, I see that, especially putting the tenants at risk of losing that land if there's not a provision.
and we have a new publication that will be released shortly about using long-term leases in
Ah,
farm succession planning. So
I
stay
I
tuned for that.
I should have highlighted that one here. I'm
Mhm.
highlighting one of our bulletins that we have on the statutory termination law that's now in effect. And you can find that on farmoffice.osu.edu in the leasing library. But also, Robert just completed a new bulletin. Our newest one is what's the title of it, Robert? Long-term leases.
Then
There's more.
succession planning, I
And
should
succession
say. Yeah,
planning.
something
Okay.
like that. Yeah.
Okay. So that one is now available in our leasing library on Farm Office. And
Okay.
I think that's a pretty interesting one. Okay, go ahead.
Okay. Question number 2. What month should a lease use
Uh,
since most cash crops are fall, but winter wheat is planted in the fall and harvested in July?
yeah.
He loves talking about winter wheat.
Well, September 1st is the statutory deadline, and I think there's a good reason for that. We're looking before we get into harvest. Let's take care of this, this this deadline, this need to either renew or terminate by then. So that's the plus side of that. But I think there's a downside to going that early. And that is you, especially if you're dealing like with a share or a flex situation and you don't yet know how successful was that tenant this year with this crop, and do I want to continue to rent to that tenant? So I've seen dates that go from September 1st all the way to the end of the calendar year. I've even seen a few that go into early winter in January or so. In practice, Robert, what was your favorite date to
I would
use
use the calendar date for the lease, but then I'd have a September 1st notice
for
that if
the
you didn't,
termination?
right, if you didn't want it to renew or you wanted to terminate the lease, that had to be provided by September 1. So that September 1 is going to address your wheat issue. So that's typically how I would do it.
Yeah. And I've looked around the country at what other statutes say in other states, and they seem to be right around September 1, September 15, October 1, somewhere in that period seem to be very common for giving the notice or the renewal. But
Yeah.
as Robert said, usually the lease itself goes until the end of the year. And in our statutory termination law, I didn't highlight this earlier, but it says the effective date of the ending of the lease would be either December 31st or upon completion of harvest, whichever is earliest. That's when the lease actually terminates. So that's written into the law.
So sort of tangential, but we were at a conference yesterday, and I thought a really interesting comment was, well, if you're in a share rent situation and you terminate September 1,
That's
what
a
are
little
the
risky.
odds that you're going to see the lowest yields you've ever seen? So keep that in mind about share versus cash versus flex.
That's a
Uh,
good point. So kind of design your termination and renewal dates according to the type of lease
I think it
that
matters.
you're
Yeah.
using.
Mhm.
Yeah.
Yeah. A share, maybe you wait till December 1st when the crop is off. So, mhm.
Yeah. So it
Okay.
depends is the good answer for that one.
Okay. Um, all right. We have a written 4-year farm crop lease, but no termination language. Does this fall to the statutory law? Example, as landlord, I could submit in writing by September 1st that I would like to terminate for balance of contract period.
Oh, well, no, see, I would think, if I'm understanding correctly, if you know that it's a 4-year lease, you do know what the period of the lease is. So it ends at the end of that period, even though it doesn't say anything about renewal or termination. Would you agree, Robert? You're shaking your head.
I would.
So,
That was my thought. 4 years means it ends 4 years
yeah,
after it was signed, most likely. Mhm.
period. So if you try to terminate it before the end of that period, then we are looking at wrongful termination, unless there's a provision in there that would allow you to terminate for a certain reason, like non-payment of rent, then you might not be at risk for wrongful termination. But
Yeah. Of course, we haven't seen the lease, so you should consult your own
yes.
attorney for legal advice. We only educate. So,
Yes.
okay, another question. Question for Peggy. There are a dozen farms in Ohio that have 60-year farm leases with NPS who want to eliminate farming on all their holdings.
The
I don't,
Park
are you
Service, the National Park Service.
okay? Uh, 12 of 14 are gone in California too. They seem to ignore the lease once farmers meet all their demands. Sorry. Means to say they come up with new reasons, many making it impossible to even farm. Realize this is unique as a landlord as the federal government. But I think the question is, what do you do with a landlord that keeps coming up with new reasons for eviction and termination, and it is never ending? Peggy, I'll just let you handle
Oh
that
my
one.
goodness. That is, that's unusual. Um, And you're right that it's complicated by the fact that you're dealing with the federal government. I think it's unusual to have a 60-year lease, but as soon as you said that, I thought it must be a government lease because we do see those in governmental situations where they don't want to have to mess with it. They just lease it for those lands. But let's see. But if they're ignoring the lease provisions, I mean, your best option is to hire an attorney and enforce the provisions, but that's going to cost time and money. Sometimes just that letter, that recognition that you are paying attention, a letter from an attorney can kind of straighten things out without having to go into litigation. So that's the approach I would use. Um, Robert, what else?
What about mediation?
I wondered if you were going to say that. We do have our Ohio Farm Resolution Services here in our OSU Ag Law program now, and we offer mediation services. And so if there is willingness by NPS to engage in mediation and kind of clarify, review those leases, clarify the terms, reach a new understanding, then we could certainly help with that in offering some mediation services. And I should say that sometimes when we do get into those longer term leases, I had to deal with a lot of these when I was out west, longer term leases with the government. Uh, Sometimes the people in charge really haven't looked at that old lease and don't know the provisions. They're just kind of operating on what they were told or what they think. So sometimes just sitting down and walking through that agreement can go a long way toward reaching some clarity. But I don't know if that's the situation that you're dealing with here with NPS in Ohio, but I think that would be a good recommendation. Other recommendations,
Oh,
Robert?
I was just going to say, when the government is the other party, they are just another, tell me if you agree with this, Peggy, they are just another party to the contract. So you still have rights to enforce the terms of the lease and sue for damages, but the government is the government, and you know, they may be a little more difficult to deal with in certain ways, and the bureaucracy and all that. What's your experience with the
Yeah,
government
yeah.
being the other party?
I had to deal with that a lot in Wyoming, and because they do own so much land, hold so much land in Wyoming, and yeah, we treated them as another party. It's just that they're, a bigger party, and sometimes more distant. You have to track down who's in charge of that, where are they?
Mhm.
But the legal rights aren't any greater just because they're a government party in this leasing situation.
So if you feel like the government is not holding up their end of the lease, you have all your rights. It's just that government's big and you know,
Yeah, can
you
drag
know.
it out, and just like a big company, though. I mean, you could see that with a big
All
company
right.
as well.
We got more questions. I'm hoping one of these stumps you here
Oh,
eventually.
goodness.
If the landowner who has a verbal lease with tenant is deceased, okay, so if the landowner with verbal tenant is deceased, does the successor need to send a
Uh,
notice to the tenant to terminate? Wow, great question.
yeah, I've had that question recently. It has happened a couple of times. Um, do you have to? The law doesn't really address this particular situation, but should you? Yes, just to get that clarity
Yeah.
out there. And it might be that that tenant would challenge that.
Mhm.
But I think just to get that clarity for all parties involved, let's clarify that this is ending as of this date, and see what happens. And then maybe that's an opportunity to renegotiate and get a written lease in place as well. But sometimes the questions I've received, it's the successor to that deceased party wants to farm it themselves. And so they're in a bit of an awkward situation. But I think you've got to clarify and see what kind of understanding that tenant has on how long that lease was supposed to last. Robert, you want to add anything to that?
Send the notice.
Yeah,
Then you don't have to worry about it.
yeah.
Okay, you mentioned it's a good idea to record the lease. Can you discuss this more and how typical is this done?
If you're dealing with an ag attorney, it's going to be very typical that we file a memorandum of lease. And so what Ohio law says is when you do that, it can just be a very short form. You don't have to disclose your rental amount, any financial information. There are just a few provisions that have to be in that memorandum, very simple, one page. And when I was in practice, when we did a lease, we always did the memorandum too, had the party sign both of them. And the lease said the parties will agree to sign a memorandum of lease, and then we take that memorandum and record it. So it has to identify the parties, the land that would be under lease, and the renewal and termination provisions to clarify. And that gives then notice to any potential purchaser or someone who wants to lease that land. That gives them notice that, nope, there's a lease in place on this land. Robert, did I miss anything there?
I would just say I typically, if it's just a year lease or maybe two, I didn't worry about
Worry so much.
recording it because worst case, you're stuck with a 1 year lease. But if you're talking 3 year, 5 year, 10 year leases,
Yeah.
I
Or what
think
about a
it's
1 year with an automatic renewal? You'd want to maybe
mhm.
get that in. Yes.
Right, right. So if it has the potential of being long term, I would do it then. But if you're doing, we talked about drainage tile before and a 10 or 15 year lease, when tenants putting drainage tile in, absolutely the memorandum needs recorded. You can record the lease, but it's so much easier to record a memorandum. It's shorter. And you don't have all your lease rates and all your provisions you might want to make private.
Hmm.
That's not recorded. Okay.
And we have a bulletin on that in our leasing library on Farm Office about the steps that you need to go through to have a legally enforceable lease. And part of that is, also then filing the memorandum of lease. So that's explained in that bulletin.
All right. I think we have a follow-up from our National Park Services question. It says mediation is in the lease, but it hasn't happened. Attorneys can't keep up with their changing
Uh,
story.
Well, if
So,
there's a mediation provision and they've already agreed that they would mediate, we would certainly be happy to help out, or take that to any mediator. You might have to go through steps as to how you demand mediation. follow the lease provisions for that, and then see what happens. Sounds like a good case to mediate.
Well, that's all of them. We didn't get you stumped, but
Well, you covered for me too,
mhm.
so it wasn't just me, we.
Any final questions or comments? I don't see any.
Okay, well, I need to move quickly through the next section then to leave time for Barry, because everybody wants to hear from Barry on his numbers and information on where we stand on some of these issues financially. So I'm just going to quickly highlight another leasing issue that we're keeping an eye on here in Ohio, and that is leasing the pore space beneath your farmland. And if any of you have, been approached with that offers to lease your pore space, we'd love to hear from you and learn what you're receiving and what those kind of circumstances are. But you may, as a landowner, have someone knocking on your door someday or sending you something in the mail saying, hey, we'd like to lease your pore space. So I want to alert you to that, why it's happening, why we're talking about it, and what is pore space exactly. Well, we don't have a statutory definition for pore space in Ohio yet. We might with some legislation that I'm going to tell you about. But what we're referring to when we use that term pore space is those cavities beneath the surface of the land that can store resources like brine water or gases, liquids. And the one that's of interest now is injected carbon. So carbon capture and storage is the force that's driving this interest in pore space leasing right now. And that's because there are those who stand to gain from removing carbon from an emissions point, keeping it from going into the atmosphere, removing that carbon before it would get to that atmosphere, I should say, and instead converting it and injecting it into pore space and having it there for long-term storage of that carbon. So it's a I guess a kind of a climate mitigation type effort to keep carbon out of the atmosphere. Whether that carbon would be used in the future, we don't know. If there's something developing and some interest in that, that could be part of what's behind this as well. But that carbon injection technology would work through a Class 6 EPA regulated well program and allow that developer to capture carbon and inject it into pore space beneath the surface of land. So it looks something, kind of a simplified example here, just so you can see an illustration of what happens. They would capture that carbon at that emissions point and inject it into pore space far beneath the surface of the land. And you can see there, the pore space is that dark area that would be between particles or sediments or that space that's available. Okay, so we do have legislation in Ohio that's currently proposed. It has not yet passed. There are two different bills. One is moving, the other is not. The House bill is moving. House Bill 170 has had 4 hearings already before the Natural Resources Committee in the House, but it has not been voted on. But what that bill would do would first kind of give us a legal definition of pore space and clarify who is the rightful legal owner of pore space, and can that owner separate and convey pore space as a separate property interest. This bill would clarify all of that, as well as clarifying, well, if you have severed pore space and you have several mineral rights and you have surface rights, which one takes priority in different situations? And the bill would clarify that as well, so that we can understand if someone wants to, to act on their pore space rights, can they do that in relation to a different owner having surface rights and maybe another owner having mineral rights? So it tries to bring some order to that potential chaos that we could have with different severable property interests. The bill also would authorize this kind of carbon capture technology in Ohio, allow those wells to go into place, but it would first require the DNR Division of Oil and Gas Resources to create a regulatory program. There are some provisions in the enabling legislation here for that program, but it would hand it off then to DNR to make the final rules that would address the operation and monitoring of those wells and the safety and the spacing. All of those kinds of issues would come through that rulemaking. The bill also would allow what we call pooling, forced pooling, or consolidation, or some, yesterday we were referring to it at our meeting as eminent domain. It would be eminent domain by a private party though. So I prefer to use the term consolidation or forced pooling, which is what we see in oil and gas. If you're trying to get assemble a project area, but you've got some landowners within that area who don't want to be part of that project, the bill would say, well, if you get at least 75% of the landowners in that project area, you can force in the rest of them if you follow the procedures for consolidation, as it's referred to in the bill. And there would be payment, of course, to those landowners who were unwilling to enter, but they'd be forced in. It also would address well closure, liability, those kinds of issues that we need to address whenever we're talking about this kind of a mining or type injection well type situation. The liability for the carbon dioxide, those kinds of issues. It does not address pipelines at all. And from what I've learned about this technology is you really can't do it without pipelines unless you are injecting right below the surface where that carbon is being created. And so we need pipelines to move it from the place where we're capturing it to the place to the well where it will be injected. This bill does not address pipelines, and that's certainly a concern for landowners. So other issues for landowners other than the pipeline issue is without legislation right now in Ohio, it is gray how we define pore space and who has rights to pore space. There is no clarification that you can even sever your pore space interest and lease it to someone else. So without the legislation, it's all very unclear right now under current law. And something I want to point out to those who may be approached with one of these leases, they're written in favor of that party who wants to lease the land from you. That's just a given. It's going to be written in their favor. And typically they're written overly broad whenever we're talking about any kind of an energy or resource development type lease. Very common that it'll be written overly broad to try to accommodate situations that might arise in the future or rights they might need in the future. So be aware of that. They can take some pretty broad general rights in the property, in addition to just what you might think you're leasing, the pore space. They might include pipeline rights or some other rights that are buried in the lease. At our meeting yesterday that we've mentioned a few times, someone said they found a solar lease that had pore space rights embedded within it. So you really have to be careful about understanding what rights are we transferring. And if they're broad rights, that's a good reason to say, let's slow down, let's clarify some things. And the big question that we have, of course, is what is the value of your pore space? How much should you be paid for leasing your pore space? We don't have any data on this. It's a very new property interest. Here in Ohio, I've heard some numbers from Texas where this is going on. How do those compare with what we should see in Ohio? I don't know. I've asked Barry the question. Barry, can you give us a number? Not a question he wants to hear, but it's a great unknown right now. And there's a problem with the fact that many of these leases already have confidentiality clauses in them that say you can't share the details of our leasing arrangement with anyone. So we can't even look to the few that may have been signed in Ohio and ask, well, what are you leasing yours for? It's confidential. So that value question is very uncertain. So just quickly, if you do receive a poor space lease offer, we would caution you not to just sign it right there. They're going to try to use pressure tactics, do it now, those kinds of things that we typically see. I'm not trying to bash anyone here. That's just how it works. But remember, those early offers are usually the lowest offers. And if anyone's trying to rush, that means they don't want you to take the time to review all the details and provisions of that lease. So we, of course, would recommend having an attorney involved. We know some have already been doing that for landowners, review and negotiate that lease. And we've got to keep seeking information about what is the value of pore space. And I would caution anyone, don't sign a lease yet. Just wait on the legislation and the rules. Because once those are in place, you can embed all of those standards within the lease. If you're signing the lease now without any of those standards and those standards aren't addressed in the lease, then you could be in trouble with some of those issues. So I hope that wasn't too quick. Are there any questions, you guys, about pore space leasing that I need to answer before I hand it off to Barry?
I don't see any, Peggy.
Don't see anything. Okay. We're following this on our blog, so keep an eye on that. And then I'm working on a carbon publication that will cover some of these issues as well. So with that, Barry, I will hand it over to you.
Okay, thanks, Peggy. Some new and interesting issues, and look forward to following that as well and seeing what we end up with. And perhaps will be some new income possibilities for folks that have land throughout Ohio, and hopefully it's not going to be too controversial. It seems like there's some for and against this possibility. Okay, well, thanks for hanging in there, folks, at least to capture some of the information that I'm going to share. Peggy, I think your topic seemed to generate the most interest, and you and Robert did a great job answering those questions. Okay, I'm going to share some survey data and rental outlook for us for this year and next. And there's a few discussion points. I'm going to talk first about economic outlook for crops. However, it's not a pretty picture right now, unfortunately. We'll talk about some data, and also we'll dig into current ag use value and property taxes and how that might impact lease and rental rates. And last, we'll talk about strategies and discovery methods that you might use in coming up with rental rates. So today's discussion, at least my topic, is going to be mostly focused, almost exclusively focused on cash rent issues. Okay, crop share issues, I'll refer to a little bit, but not the bulk of this presentation. First of all, the economic outlook, and I put this graph up here, and this is data that we've collected and used from our enterprise budgets. We've also included income as a result of government payments and insurance payments, crop insurance payments, in this graph, looking at returns to land, and this is per acre for Ohio soybeans, going back to 2005. This just illustrates the real difficulty that we get into in negotiating cash rents from year to year, or from period to period, I guess. And the real issues come into play where we have these real high income periods like we did during this 2007 through 2013 period. And then again, more recently, when we had 2019 through roughly 2022, where we had these high income periods driven by a number of factors, and resulted in what we have today with escalating land values and cash rents. The issue then becomes when we come off of those highs in that period where we're in now, this kind of trough, if you will, in income. How do cash rents react to this lower period of profitability? With this volatility that we're seeing in profitability, it creates real headaches in that relationship between the landowner-landlord and the tenant farmer. If we just had a nice steady blue line across here as we're showing, if we had our profitability maintaining a fairly level kind of year-to-year return, it would be a whole lot simpler. But with this up and down, it certainly creates some headaches for us as we try to figure out and negotiate a cash rent that's acceptable to both parties and is equitable to both parties and doesn't create, I guess, negative feelings towards one another when it comes down to it. Okay, so first of all, looking at our 2025 profit picture. The first slide here is corn budget for an acre of corn, a typical acre of corn in Ohio. I know it's not going to be one that will probably be similar to all of your farms, but we think that it's going to be close or in the ballpark, if you will. Now, we had crop reports, USDA reports that came out earlier this week that really moved our prices for corn and soybeans and wheat too for this upcoming year and also for next year. And corn really took a beating. Okay, so we had a little bit higher corn price projected for this year. Now we're plugging in close to $3.75 a bushel. Corn crop is expected to be, well, for lack of a better term, humongous, and really has influenced these crop prices, and it's going to influence our bottom line too for those that don't have a lot of the crop already priced. Now, this 190 is a trend yield for Ohio. We may have areas in Ohio that are going to be closer to this higher yield that we're seeing on the right-hand column. But if you look down here in terms of returns, you can see it's mostly negative. Return to land for trendline yield corn, 190 bushel corn at $3.75 a bushel, assuming the input cost structure is what we have. And most farmers are going to be different. Some larger farmers or those that are more efficient will have a lower cost structure and the returns might look a little bit better. But this negative number down here is not a good sign and really, well, should influence cash rents. Whether it does this upcoming year, that's another story. Soybeans look a little bit better. Right now, we're plugging in $10 a bushel for this fall delivery. Bean market did improve a little bit as a result of the reports earlier this week. 57 bushel beans, returns to land, still positive, but not very high. Not a number that really drove rental markets higher from 2019 through 2022. Okay, just real quick on input costs. This is more information than many of you want, but generally speaking, as we're going into 2026 and looking at all these input costs that farmers have to pay for, most of them are going to be fairly flat. Not a lot of relief here, okay, and not a lot of upside, however. So at least we're probably going to see most input costs or the average input cost per acre remain relatively stable. What we'd like to see is some decrease in those input costs reacting to lower crop prices. But these things take time. And oftentimes during this period of crop prices that are trending lower, input costs take a while to catch up, and some never do. Some are very sticky and don't always react to lower crop prices. And that's what we're seeing right now, is that lower crop prices still fairly sticky and persistent input costs, resulting in challenging profit times and in some cases losses per acre. So that's what we're looking at here as we go into 2026. Okay, real quick on cropland values. I know we're not here today to talk about this, but it does correlate pretty highly with what we're seeing in the rental market on the cash rent market side. The USDA NASS data. Okay, they survey annually and they publish an average cropland value for Ohio and all the other states, as you can see by this map. The 2025 survey summary that they complete showed average farmland, and this is across the state, east to west, north to south, $9,700 an acre, increase of about a little over 5%. So still some strength there in the market, although this survey indicates things are slowing down a bit. We can look at more data, and our college or our extension survey that we conduct annually showing cropland value in Western Ohio and increasing a little bit lower than what the USDA survey is showing, somewhere between 0.5% to 4% increase, depending on the region and the land class. This is on top of big increases from 20 to 24. You can see there at that bottom line, from 43 to 62% increases in farm cropland value in Western Ohio, depending on the land class and the region. So just giant increases. And most everyone here on this this webinar today, you're very aware of this. You've seen some of the results and you've seen some of the auctions that are occurring in your own communities. Just big increases driven primarily by high profit years in 2021, 22 that drove a lot of this. Okay, so that's another set of data, data set 2. Here's a third set. Now, this doesn't include Ohio, and you've heard me talk about the 7th Fed District before. This is just another set of data that we can look at. It includes our neighbor Indiana in the 7th Federal Reserve District, and showing in 2024 weakness in the farmland or good farmland markets in that particular, in the whole Fed district, and more specifically the red bar being what happened in Indiana during those periods. And you can see in 2021, 2022, just giant increases in good farmland value as we have experienced. 24. Now, I saw the recent data in the second quarter from the Fed, and they publish information quarterly, and you can find this all online. It's all public data. But Indiana showing for that second quarter a very strong farmland market, according to their survey of bankers in Indiana, showing about a 7% increase in farmland. That seems a little suspect to me. It seems almost too strong. I don't know if I believe that number, but it is, however, showing some continued strength into the early part of 2025 in the farmland value market. One other source of data, and this is a relatively new partnership we've agreed to with acres.com. Some of you are familiar with this entity. Acres.com has a relationship, also a partnership with Purdue University, and what they're sharing with us is summary data from each crop reporting district across our state on actual farmland sales. So they're collecting this data at the local county level, all the sales that are occurring throughout the year, and they are sorting this out. They're looking at all these sales. They're backing out any information that might be in those sales related to structures, barns, grain bins, all those things that typically might be included in certain sales, and also residences. They're backing that out, showing us what those actual results are on a per acre basis. Generally, they showed in 2024 still some strength in the market, farmland sales again, and for some crop reporting districts showing a little bit of weakness showing up in some of those regions. So again, this is farm sales data. This is actual data. We're excited about this partnership with acres.com, giving us some ability to ground truth some of our survey data. And I'm sorry, there's two different, this is price per acre on per crop reporting district. This is tillable acre. So this is that second set of data that I was referring to, where they are removing structures, residences from each individual sale. Okay, so that's some data that you can also look at. I know I've referred to this and talked about it in previous webinars, so some of you have already seen this. Okay, to what we are actually here for, and that's talking about rental issues and how it's going to be a challenging period to come to some agreement between landlords and tenants on what that equitable rate might be going forward. USDA NASS data, this was just recently released, looking at the average cash rent for Ohio in 2025 per tillable acre, $184 per acre. Now you can see there's a red number just above that. It's the first time in recent memory where we've had a average cash rent decrease in the state of Ohio. So it went from 184 to, or 185 last year in 2024 to 184 this year in 2025. So a decrease. I think this, it seems reasonable. Whether or not that's actually what's occurring in your own individual communities, well, I guess that's something for you to consider. Another set of data, this is also the USDA data. So the USDA publishes an average for the state, and now they also survey and they collect data and average per county. And this is the 24 data. The 25 averages per county won't be out until in a few weeks. We'll have some of that data showing up, I believe, here yet in August. There will be new data to share. But this is showing the 24 data. Now, there's some counties that didn't have enough responses. Those are the counties that are showing up in white. But this will give you a little bit more information to go on if you're trying to find that rental rate that might be important for your own tenant farmer and landlord relationship. Okay, and I pointed out just a few of those, but you can find that data online through USDA NAS in Ohio. Okay, I mentioned the Fed district data. They also publish and they also report on cash rents in their Fed district each year, once a year in the spring, and they will report on change in cash rents in the Fed district. The red bar again is the Indiana results showing increases in cash rents during that period, and more recently, Indiana cash rents still showing some strength in 2025 as compared to the entire Fed district that is showing a little bit more weakness in the cash rental market, a negative change from 24 to 25. So I'm just showing you all the data that I have and I can share with you to give you at least hopefully a little clearer picture of how you might negotiate in your own situation. Okay, our survey, our extension, our college survey that, again, we conduct each year, cash rents are expected to, and this was just recently published here in July, cash rents are expected to increase in 25, 1 to 1.8%. So a very small increase, and one could argue that's close enough to zero that you might even argue that there's relatively no change in rents across Ohio in 2025. This was a survey that was conducted back in the winter, and folks that participated in the survey were asked to project what the rents were going to be in 25. So most of those were already pretty much set back in the fall or even late summer of 24 when folks were negotiating rents for 25. So I think that those respondents probably had a pretty good idea of how rents had settled in their own communities. This is on top of rental increases from 20 to 24 of significant change, not to the level that we saw with land values. Okay, but rental rates did increase substantially, 15 to 27% across Ohio during that period. So substantial increases, and increases that, while they looked good during that period, now as we're entering this lower profit margin period that we're experiencing now, probably look to some farmers that it may be a little bit unpalatable to manage those during these low margin years. Okay, specific data. All right, we survey Western Ohio, and we survey the entire state, and we're not trying to ignore Eastern and Southern Ohio. We do survey the entire state. It's simply a lack of data in those regions that don't allow us to publish summary data, summary statistics for those regions. So that is why a year in and year out, we only publish a Western Ohio survey summary. And we break it out into two more or less distinct regions. Northwest and Southwest, which the Southwest region you can see in a moment looks more like West Central. Perhaps I should change the title of that. But now we do know that the entire region, and you can see that in the map here, is not homogeneous. It's not all the same, but it's similar in rental characteristics. So that's why we do include all of these counties in this region and summarize the data. You can see here on the right-hand side all of our data, and this is we're asking respondents to report on land values and cash rents by land class, average, top, bottom, asking them to report on what is an average corn yield for average land in that region. And you can see here for Northwest Ohio, where average land, including some of the ups and downs that we experienced with a poor year here and there, almost 200 bushel an acre for corn, around 61 bushel for soybeans, average 13,000. Now we know that doesn't capture some of the sales across this region where we see 15, 18, 20 plus $1,000 per acre in some of those communities. But overall, the respondents felt like 13 was about right for average. And rental markets somewhere around $259 an acre. Now this data, and I'll repeat this probably again, this survey summary is not meant to be data that you can take and in Marion County on Smith Road and say that this is the rental rate that we want to use for our farm. The summary of this survey data is not meant to be used like that. It's meant to give you an idea of what might be the range, and I would encourage you to look at the ranges in these reports, utilize those, but it's not meant to be that number as the rental mark or the rental rate for your own individual farm. Sometimes I get those questions. This is a big region, Northwest Ohio, if we just look at these counties. And there's big change from Morrow County all the way to Williams County in terms of soil productivity and supply and demand in each of those townships and communities. So this gives you an idea, more of a trend, if you will. And you can see that the trend, I would argue, in 25 coming out of 24 is relatively flat. And that's basically what I would have expected as we look at this. Now, top land, another thing that I'll just caution too is that sometimes I have folks that assume that breaking this down into a third, and a third of the land in a particular region. And I would counter that and say that probably we're looking at somewhere around 2/3 of the land in that region are going to fall in this average category. Okay, with the remainder, 10 to 15% perhaps in each of these top and bottom categories. Okay, a smaller percentage falling into that top and bottom land class. So land that's going to fall into the top land class, large parcels, highly productive, renting for much more and on average, and also selling for much more. And also the bottom, we're talking about land that's fairly marginal, not really good productivity, not the soils are challenging. And you can see how those relate in terms of both value and rental rates. Okay, so one more piece to this, and I know, as I've mentioned, and I've talked about this for several years, and I've also gotten pushback by some out there that, this is, it's somewhat meaningless as we look at, for example, if I'm in Marion County and I'm trying to use this data, how do I localize this data to my particular county? Okay, so what I've done, I've taken that USDA NASS data that's publishing averages by county, and I've used it to create an index. And I've already shared this in previous webinars, but I wanted to go a little bit further with this, with the usage and how you might use these indices. All right, so if we look at all the different counties in this particular Northwest region of our survey, and we look at that NAS data and we use the county averages, and we average those from 2017 to 2024, that gives us an average cash rent. And then we average all of those in the region, and then we compare how those look to the average in the region. It's going to give us a percent of the average. So if you can follow my logic and all of that math, then you can see that we look at Allen County, for example, or we can look at Van Wert County, and those counties showing up at 114%, meaning that likely they're going to be counties that are going to be a little bit higher in terms of rental market as compared to some others in the region. So you can see not homogeneous, Hardin County being the highest. We've got some counties looking at Defiance, Ottawa, Morrow being pretty low in terms of the percent of the actual average in that region. So how can we use this? So we take these numbers, we multiply those, we go back to this average $259 per acre. And we look at the Marion County index at 98.8%, and we multiply that by the $259 an acre, and it gives us 256. So in other words, this is a way to somewhat localize the data that we're sharing in that Northwest region of Ohio. It's not a perfect or a precise tool. It's more of a rough tool that will give you at least some idea as far as how your county might compare across that region, and using that data then and looking at those ranges. Yes, okay. There was a question on here in your most recent survey. I'm trying to understand the rental rate discrepancy between years. Okay. It's a good question, one that I get often, but what we see is that we have respondents that are responding, for example, in the 24 survey year, and that would have been the winter of 24. They're asked to report on the actual cash rents in 23 and also projecting what the rental rates are going to be in 24. Okay, the same thing would have been done in the following year. And what I would suggest is that as you look at those, the actual rental rates that you're going to be looking at in terms of a particular year are the prior year in that survey summary. Okay. The rental rates that we're publishing in the survey summary for this year in 2025 are an estimate. Okay. So when the dust settles, in other words, this is what we're finding as far as those rental rates. So sometimes we do see some corrections in the following survey summary that would lead us to believe that, okay, our respondents perhaps were a little bit more optimistic than what the actual results likely were in a given year. So that's why we do see some discrepancies from survey to survey as we look at, for example, what 24 showed in the year, the 23-24 survey, as opposed to what it showed in the 24-25 survey. So I hope you understand that. We're not, well, I guess in a way we are retroactively updating because we do see, and I don't want to use this analogy, but the Bureau of Labor Statistics often has to go back and make changes based on more current information. So I hope that doesn't mean somebody's going to fire me because I did, because there are some changes in the data. But that's the way I see it as far as our respondents giving us information. Sometimes there are corrections, if you will. Okay. I'm happy to answer more questions on that, or if you want to have a longer discussion, feel free to call me. Okay, now we go into West Central or Southwest Ohio, the region in the state that we typically see the higher rental rates and values, and you can see this showing up in the data as well across this region. So very minor changes, almost flat in terms of rental rates, a little bit more increase in terms of land values. Here's the index for that region. allowing you to compare and contrast and localize your information, if you will. Again, this is a tool that it's not a precise tool, but it's a tool that will allow you to do some general comparisons from county to county. For example, you can look here at the one that shows up most often is Dark Mercer, where we typically see some higher rents. Mercer and Dark, almost 110% of the average. Fayette showing at 111%. This seems suspect to me, and sometimes the data coming out of these averages, the NAS survey summaries, you have to use with a little bit of understanding that this is not a perfect exact science either. This is survey data based on respondents. Okay, percent of land value. One of the things that we used back in the 1980s and early 90s as a tool, a rule of thumb on rental rates, was a percent of land value. So if we knew the land value of our farm, we could estimate what that rental rate might be based on a percent of land value. And that was generally in that 4 to 5% range back then. Now we see that this has trended lower. Very strong land market, land value market has driven part of this. And well, I would argue probably most of this change in terms of a rent as a percent of land value. And now we're hovering around this 2% rate. Okay, so as we look forward into 2026 in the near term, what are the key fundamentals that are going to be impacting rental rates? When we look at, I would argue that there are two primaries. One is farm net worth and equity, still driving many producers' ability to be able to bid higher rental rates and pay those rental rates. And we had positive outcomes, in some cases extremely good years in 21, 22, to a lesser extent in 23, that allowed net worth to build and allowed farmers to bid up rental rates in some communities. Also, CAUV values being higher, property taxes along with them have led many landowners to request higher rental rates. On the other hand, we are in a period now that looks to be a mean reversion, a correction, if you will, almost an overcorrection in terms of profitability. And 24 was challenging, 25 more so. And as we look forward and look out into 2026, I see more of the same in terms of challenging profitability. The one thing that may offset that slightly is that some of the Farm Bill provisions that were included in the One Big Beautiful Bill did increase reference prices for many of our row crops, including corn, soybeans, and wheat, that may allow for some payments to be triggered when in the past they might not normally have been triggered. Lower prices that we're seeing in the market together with those higher reference prices might result in some more government payments to producers in the coming years. Time will tell. Overall, as I see going forward into 2026, as an economist, I would predict and say that rents should come down. As more of a pragmatist and a realist, I would say that probably what we're going to expect to see is cash rental rates remain level. Okay, CAUV values, what is driving those? What is changing? And we're seeing a change of these current ag use values that will impact property taxes. However, it takes time, and they're still high, and people are still having to deal with these higher property taxes on farmland. You can see this map on the right. This is provided by Farm Bureau. I appreciate their map here. This is showing how you and when your county it gets reappraised or updated. And then you see the change in property taxes the following year. So the green counties are going to go through that reappraisal or update, and they're going to see higher property taxes in 2026 as a result. Variables that drove higher CAUV values, and this is based on a formula. Farmland values are valued based on a formula, not like other properties, not like residential or industrial that's based on comps or comparables generally. Higher crop prices, lower interest rates, higher crop yields primarily drove these higher CAV values that we've experienced. And now we're going to go and see these start to fall again, driven by lower crop prices entering the formula, as well as some of these higher interest rates that we've experienced recently. Here is a graph showing you for those counties that I highlighted there in green and that are going to see reappraisal or update in 2025, you're going to go from the average value for your own or each property, or for all the soils in Ohio, I should say, of $990 an acre in 22. And we only do this every 3 years. That's why we often see sticker shock. In 2025, it is certainly higher, from $999 to $1,469. So you're going to see higher property taxes next year on your farmland. However, you can see the trend has changed. Okay, those counties that were reappraised or updated last year, average soil value compared to this year. So we're going to start to see this downward trend again as we see these variables change in the formula. Not great news, but at least the trend is positive for those that are having to pay property taxes on farmland. Okay. Rental strategies and discovery methods. I wrote down a couple of notes to myself ahead of this as I was thinking about this. One of the more difficult things, and one of the things that in talking to both landlords and farmers, it creates a lot of uncomfortable feelings in negotiating rental rates, or especially revisiting those rental rates. In some cases, real anxiety in having those discussions. Sometimes those folks, that relationship's an ongoing one for years and years. Possibly you went to school with them, they're living in your community, and that creates those issues as well, that we have to continue to live in those communities while we either negotiate hard for higher or lower cash rents, or in some cases we have to sever the relationship. So that's some of the things that we don't often think about purely as we look at the survey data and kind of the economics of the situation, but we do realize those are not simple. So rental strategies and discovery methods, there's no revelation here either, but just some reminders. We know what some of those factors, general factors, not the specific ones that I talked about earlier that are influencing and likely will influence the land rental market, but general factors. Expected crop return, size, shape, perimeter of fields, location, services provided by the operator can often be, for some landlords, good, significant payment in lieu of cash. If you have a farmer tenant that is going to be giving you a certain amount of service, then that should be considered as payment in lieu of cash, in my opinion. Oftentimes, the reputation of the other party. Some folks will hang in there with someone that may not be paying them top dollar. A landlord may not be really seeking top dollar because they have an easy and good relationship with that tenant farmer. In some cases, there are trade-offs as well, where you as a landlord may be incentivizing a beginning or a small farmer to continue farming in your community, and may not be seeking top dollar that you might get from another farmer. And there are local supply and demand factors. One of the reasons why I feel like rents probably won't decline is that we have still a number of farmers in each community that have relatively good net worth that's going to continue to allow them to hang in there and pay these higher rents, even with a really challenging year this year and last and likely next. So folks that come to me often, some will, ask for a number. It's not a fair question, is to ask for a number on what the rental rate should be on my farm in the corner of Defiance County. Certainly not something that I can really weigh in on. The best I can do is give you the information we have and really encourage you to educate yourself. You have a a very valuable asset, and one that you need to be aware of what's going on with that asset, not only in terms of the quality and the production capabilities of your individual farm, but also what the current economics of crop production are and the ups and downs. And also would add one to this and understand the dynamics in your own county and township in terms of the rental market, because that's something that's hard for an outsider to see. What are all those potentials in terms of landlords or tenants that I might have, whichever party I am. That's difficult for someone working throughout the state or working at the state level to really understand. If you want to know the quality productivity of your farm, most of your soil and water conservation districts or other entities within your county will have a soils map that will give you an idea in terms of soil quality. Some of you may just have institutional or historical knowledge of your farm in terms of how it stacks up quality wise. This is an old bulletin 685. This was completed back in the early 80s. This was an effort by Extension, OSU Extension, as well as NRCS, which used to be, I think at that point, Soil Conservation Service. And they ranked and they indexed all the soils in Ohio. So this will give you an idea, if you really want to know, productivity index of all your soils from 0 to 100. At least it will give you an idea. If you have no knowledge, it will allow you to go and look at your own farm and try to determine whether or not you have maybe a poor farm or an exceptional farm in terms of soil quality. Economics, the second point that I made, economic perspective, rent should be equal to return to land for a given parcel. That's what really is a signal to us right now. And Robert and I talked about this before. If we looked at just return to land, well, we're going to be looking at negative numbers, a negative rent. So in other words, the landlord would pay the tenant to farm. Probably not going to happen, but that's what at least that corn budget is showing us from an economic perspective. But at the very least, these signals would indicate that rents likely will and should slow down in terms of any increases. All right, survey data, I've already mentioned that. It's a good idea to understand that. At least the trends. That survey data, again, shouldn't dictate what that rental rate should be on your own particular farm. Local supply and demand environment, I mentioned this already, having an understanding, and this sometimes includes a lot of sleuthing, getting to know people, talking to those folks in communities, your extension educators, others that you trust in your community. There's old rules of thumb here. I don't recommend any of these really anymore. However, they can give you a good idea. The percent of land value, it's a moving target. It's closer to 2% now, as you saw data that I shared earlier. Crop share lease equivalent, yes, going back to, if you want to be a crop share landlord and you don't want to have to pay half of the variable costs, one of the strategies is the 1/3, 2/3 crop share lease that is used and still is used in some communities, where you contribute the land and you capture 1/3 of the crop to then market. It requires a lot more effort on the landlord's part to participate in this, and it's also requiring a lot more communication back and forth between the two parties. And that's sometimes difficult to agree on. Dollars per bushel of production, it's another way that we can look at this. However, with the ups and downs that we experience, the volatility and profitability make this challenging. Peggy mentioned this, our Ag Lease 101 website, and this is a consortium of states. This is the north central states, including Ohio. We come together to put on certain programs and put together certain publications that are going to be publications that require a lot of effort and are meaningful and applicable to the states across the North Central region. Peggy and I helped, and as well as Robert, he was a part of this too, putting together this bulletin on fixed and flexible cash rent lease agreements for your farm. And Peggy and Robert spent a lot of time updating this sample cash farm lease as well. So I would encourage you, especially if you're new to this, or even if you've been doing it for a while, this bulletin's valuable read, I think, and will be helpful for you as you think about negotiating rental rates. And that sample lease will give you a good place to start as well. So again, that's the Ag Lease 101 website. Rent discovery methods. This is nothing new. One-on-one negotiation is by far the most common means of coming up with a rent. The back and forth between the tenant and the landlord. There can be some bids, and if you really want to get a little bit more formal and really want to chase the top dollar, you can use some of these either closed bid or open to the public bids. Professional farm management firms are out there. If you really are a farmland owner that has no understanding and doesn't want to get involved in the interactions and trying to figure out what that rental rate might be, there's professional farm management firms. Then the landowner has to pay a certain percentage of that gross rent to that individual or to that firm to be that intermediary. Lesser types of discovery methods are rent auctions and rent appraisal. Very uncommon, but they are out there. Rent indexing, this is something I've talked about for a number of years, and some of you use this, where you're going to come up with a mechanism that adjusts rental payments based on changes in a specific economic index. You think about indexing on other kinds of payments. You might use the consumer price index, the inflation data. Doesn't really, it's not as useful in this particular situation. You might use the NAS survey data, the average Ohio rental change. You might use our survey data as far as looking at that average rent change to automatically index your rent and change it from year to year or every 3 years, for example, if you don't want to make those changes as often. Our upcoming Farm Office Live sessions, I'll just mention those. We've got a number of them coming up. Our normal launch is at Farm Science Review. This special edition we wanted to include in here in August before the statutory lease termination period there at the beginning of September. But you can see we've got a number of them coming up. A special edition in November, our farm tax update that Jeff and I and some of our colleagues will be doing. Many of you, of course, if you're attending, you don't need to register again. You will get those monthly reminders. But if you have colleagues, here's where they can register and be a part of our Farm Office Live sessions. Here's our website, and I'm getting close to the end, but I have to share a little bit my grandkids' pictures showing pigs and on our fishing trip this year. But if you have too much of this when you're 6 and 4 years old, this is what can result is falling asleep in the boat with Grandpa because you just had too much fishing for a given day. Okay, just mention real quick, and I've mentioned this before, there are flexible cash rent arrangements that you can consider, and some of you use these. The most common ones being a cash lease with a bonus approach and the percent of gross income. Percent of net income, it gets very complicated and requires lots of sharing, but I think it's probably the most fair from year to year is looking at a percent of net income. Perhaps with some guardrails, some mins and maxes built into that leasing arrangement. Okay, and here's some actuals. And again, I've shared these before too, but these are flex leases that people have shared with me over the years. And lastly, got 2 other regions of Ohio that I've got data. Now use this with caution, mainly because these 2 regions, we have very few data points that we're using to summarize these, 10 to 12 data points. Not enough for me to feel very comfortable with this region, but I did want to share them in case you're really searching. Rental market in this region of Ohio, fairly consistent from top to bottom, a little bit lower than what we see in our other two regions. But we're going to have some areas and some farms in even this region that are going to see extremely high rents. And then you can see this is a little dated. The last time we had enough data to publish was 23, 24. And for this southern Ohio or really southwest region of Ohio, also a little bit different rental market, tending to be on average a little bit lower. If you're in the Scioto River Valley, however, or some of these river valleys where you've got flat black soils, you're going to see much higher rents. But just sharing with you, and again, this is a little bit more dated because the last time we had enough data to publish this region was 22, 23. Okay, with that, I'm going to wrap it up. I don't see any more questions showing up. So I'm going to ask my colleagues to rejoin. And if they have any last comments before we adjourn. I want to thank Jeff for doing all of the yeoman's work behind the scenes. We couldn't do these without his help, and oftentimes he's presenting today. Sorry, man, you had to do all the grunt work.
Happy to do it.
All right, folks.
Barry, did you mention that there is a short evaluation to
Oh, I did
complete
not.
on exit?
No, I did not. But yes, we do have an evaluation, and we value your feedback. So give us your thoughts as far as this webinar. And I think, is that right, Jeff, that upon exit, they will be, they'll have an opportunity to link to that.
That's correct. When you exit, it'll pop up in a new window.
All right. Okay, well, right on time. We want to thank you all for being with us. Hopefully you captured a couple of things out of this that might be helpful for you as you go forward in your lease negotiations or setting up lease contracts for this upcoming year. We hope to see you all back with us, Farm Science Review, right?
Already.
I know. It's upon us. Okay. And there's the evaluation Jeff dropped in the chat too. Thank you, sir. And yes, Labor Day is almost upon us. Healthy and happy Labor Day. Thank you there, Clay. And we wish the same to all of you. It's halfway through August and whew, feels like summer's over.
Don't say that, Barry.
I know it. Well,
You've got more fishing to do.
I had to throw in the grandkids pictures. I'm surprised you didn't.
Yeah, I didn't think of that.
Well, you can do it
I have a
next time.
slew of them I could put up there.
I'm sure. Yeah, you got way more grandkids, but I had to, my one grandson fell asleep in the boat that day, and I shouldn't laugh at him, but he's just so cute.